everyone. Welcome to our podcast. My name is Bott, and we are here with our Associate Attorney, Janki Patel. We are going to talk a little bit today about just a couple complicated probate cases that we're dealing with, and it would be good to hear about them so you can kind of just see what types of complications actually happen when people pass away and things aren't properly set up. So first of all, welcome, Janki.
Thank you. Thank you.
Why don't you go ahead and just give us a short, just little introduction about you.
Well, thank you, Maritas. My name is Janki Patel. I recently joined Bott and Associates back in February. I graduated law school back in 2020. A rough time for a lot of us. That was during COVID times. My passion of law brought me to Bott and Associates. I knew I wanted to do estate planning, make a bigger impact, and here I am. So very grateful to be here.
Awesome. So glad to have you here, of course. I know that you kind of jumped right in and did some court calls for our firm and met with some judges and all of that. But I think what would be good is to just kind of go over two of the cases that are a little more complicated than we had anticipated. For everyone who's listening or watching this, as a introductory is that when you do have a case where you come in, someone's died, you give us all the data, all the information. We're not even sure how complicated it gets until we uncover some things or we go to court or whatever. It's really, you never know. So I always say it's good to just have an open mind every time you have a case, whether it's estate administration, probate, or trust administration. So we'll start with them. We're going to call them John Doe. So John Doe is the person who died in the first case where there was a surviving spouse, right? Jane Doe,
Yes.
and then children from previous marriage. Okay,
Yes.
so let's pretend the daughter is Susan. Okay, so John and Jane Doe, we have a surviving spouse, Jane Doe, and then Susan as the surviving daughter from previous marriage. They came to us, said dad died, right? And we said, okay, they were always on the meetings together. And I believe at first we thought, okay, this should be fairly straightforward, if that's what you recall as well.
Yes.
But then the complications started pretty early on when even before we opened the estate. So why don't you share a little bit of what you noticed in the meetings that transpired after the first meeting?
Thank you for the summary, Maritas. So initially, it looked like a happy, good, jolly family. But as soon as we started getting the court docs filed, the estate was open. That's when we started seeing the complexities of the relationship. These two, uh, Susan and then Jane Doe, they're both co-administrators. So as being co-administrators, they have to make decisions together. It's not that one can make a decision by themselves. And that was explained early on. And they said, oh, we get along, it's fine. And we said, okay, if there's no issue between the both of you, this is what we'll do. Now, as the court case is progressing, there's matters that need to be handled before we close the estate or just move on. There's lots of disagreements. There's lots of, this was not my understanding prior to our call. It's a lot of counseling that we're doing on this call as opposed to resolutions. That was not expected. So it's just really hard to gauge during the initial meetings of, hey, this looks pretty straightforward. But after, the letters of office are issued, things start to get very complex when we're trying to get answers from clients.
Yeah. And I think the root of the problem is what I remember is that they mistrust each other. Is that a good way to describe it? Yeah. And this is very common in blended families, right? We have maybe daughter wasn't really that fond of stepmother, whatever that relationship is. And then the money is there, and we're now having to decide and, distribute or, figure out. And I think they each think there's more money than there really is.
Mhm.
Which isn't, we, after looking at everything, there really isn't, it's not like a huge estate either.
Not a big estate. It's being divided between, I believe, six parties, it looks
Yeah.
like. So but
Yeah.
there's lots of debts as well, which it looks like
Mm.
one or the other is always unaware. And it gets complicated because you would like to keep an open and honest relationship and conversation every time you have a meeting between all parties. But lately we're seeing that it used to be three parties where the attorneys here trying to resolve issues and then the administrators, but now it's becoming the administrators are on the same page or withholding information and not,
Mhm.
it becomes complicated because we need to answer to the judge. We need to see how we can move forward, pay
Yeah.
off debts, pay off creditors and claims. And it becomes hard when people, you know, they're trying to beat the system. There's no way around it.
Yeah, there really isn't. And it's also, I think that when you have the mistrust and then you're trying to help them and be like advising them that you have to be transparent, what tends to happen is us as attorneys, we'll hear somebody say this, the other one says this, and then we're like, well, we have to air, I can't, like us as attorneys, we have to be neutral. We have to be like, we're representing the estate and we're representing both of you, so we can't hide secrets. So here's what all the claims are, here's all the assets, and then whatever's left over is what we're really trying to distribute.
Yeah.
Yeah. And what do you suggest with people when they do start getting those phone calls of creditors? And I mean, it's always like usually like medical bills or credit cards that the decedent, you never thought the decedent had all these credit cards. All of a sudden, we're getting all these um, really either claims or just even letters and phone calls.
That's a great question. We are always asked this question every single time we're having a meeting with a client. And my biggest thing that I say is let's not foresee things that are not here yet. People will start calling, companies will start, they're like vultures, they'll come and attack whenever they get a chance. But
Mhm.
you open up, the court documents, the court portal, where you could see there is no claim filed. It's like the medical bill saying, "Hey, you owe me $50,000," is as good as your neighbor saying, "Hey, this person who had passed owed me $10,000." Well, where's the proof? Where's
Yeah.
the claim? We have an open court case. It's wise to come file it in court. Let the
Mhm.
judge decide whether it's a valid claim, and if it is, then we'll discuss that in court. So I always tell my clients, let's not sit here and have anxiety and just panic over baseless claims because
Yeah.
it's
Yeah.
baseless until it's in court.
Yeah. And what we find is the clients just freaking out, right? To get those
Yes,
phone calls constantly, they're not going to let up. They're just constantly going to call and constantly sending letters. But in our world, it's only really valid until the claim is filed with the probate estate. And in a way, I tell clients it's actually good to have a probate estate because now it's sort of out in the open and we can eventually close the estate and no other claims can come out. So it sort of has a finite resolution when the estate's closed. So
mhm.
we are required to keep it open for the 6 months. And then I tell clients if there's multiple letters, there are lots of different creditors. I said, let's close as soon as possible because not like we're trying to dodge people. It's more like they know what the deal is. They know the formality of the court case, so they should do that on their end. Not we're not going to tell them to do so,
Yes,
right? What
yes.
do you think for this situation? Had we met them before the decedent passed, what would what should have been done? Like what could we have guided them to do better?
Definitely would have advised to have a trust in place. It would have avoided this is what the decedent's intent was, because this is what we're hearing constantly. And for us, it's as good as they told you. The world doesn't know. It's not written down. It's
Yeah,
it's baseless.
yeah,
Um, if there was a trust in place where the decedent stated, this is what my wishes were. I know I'm with a new wife. I have my children from my first marriage and this is what I wish for them to have, it would
Yeah.
have avoided conflict. It would have avoided probate first off, but it would have
Yeah.
avoided the conflict that we're having right now where this looks like I feel like this matter is going to be dragged on because
Right.
we're two parties who they're not supposed to be two parties. They're one party. They should be agreeing to everything. They're not just really seeing eye to eye. So having a trust would have laid out the decedent's wishes instead of us hearing from the stepchildren, oh my God, this is what my dad wanted. And then, oh my God, no, this is not what he told me.
Right,
Definitely.
right. There's always the verbal promises that
Yeah.
they think that we're going to honor, that no court is even going to honor. And I want people to also know that in Illinois, there's no such thing as, let me write it on a piece of paper, a napkin, and sign it. It's called a whole holographic will. Some states do honor those. Illinois is definitely not one. I actually tried one time just to see because my client insisted, no, please see if the judge will accept it. And there's no way. So I don't even try because that's what the statutes say. So important to write it down properly and get it on paper. Right.
Yeah. Great.
Yeah.
Signed, notarized, witnessed. That's the
Yeah.
only way.
Yeah,
Yeah.
absolutely. So we're going to move on to second situation. We have a client, we'll just call them Bill and Mary Jones. This was also a second marriage, and we also have two kids from the previous marriage of the husband, right? And so the two kids from the previous marriage will be Jenny and Tom. Okay, so Jenny and Tom are two kids from previous marriage, and father is the one we're talking about. It's his estate. They both died sadly within a month of each other. That was a sad situation, but now we're kind of dealing with Bill's estate. Um, Similarly, they did prepare documents, which is good. Step one is good to prepare documents. They had trust created. But then as we uncovered all the information, we realized there's so much that did not get in the trust. So we are in probate, right?
Yeah.
And we were thinking that it shouldn't be that hard. We're going to open the estate, gather all the assets, distribute, because there's really the two beneficiaries, and things got complicated. So what can you share about this case?
Um, I think complicated is an understatement. It
Yeah,
got, yeah, I think initially we had Bill and Mary as joint, and then we had to open two separate probates, which ended up being in two separate courtrooms.
yes.
That we were like, okay, well, that was just a little hiccup. Let's move on.
Mhm.
And then to uncover Bill's estate, now we realized there is the biggest asset that this person had left to his children. Um, the third party is holding it now. The issue becomes, is this a probate matter? Is this outside the probate? So Tom, who is Bill's son, has been very patient, very, understanding with the process, but it's aggravating to him as the beneficiary of the estate that there are these third party people who are withholding these assets that belong to Bill's estate. So
Yeah,
now we're involving other law firms, other opinions to see what we can do because this third party, um, it just won't allow the release to the state.
yeah,
And we didn't anticipate this going into it because the documents we had and the documents we had reviewed pretty straightforward. Language is pretty straightforward.
yeah,
And as estate planning attorneys, we're like, well, this looks pretty good. We have solid proof that this belongs to the estate. But the third party, they're disputing it. And
yeah,
yeah, now
yeah,
it's we need to handle that outside of maybe probate court.
yeah,
But
yeah.
that one's becoming very challenging.
Very challenging. And I really do not, I don't blame Tom for being so frustrated because this is certainly his dad's hard-earned assets, right? He worked
Yeah.
so hard for this, and it's clear with our documents that we see that it should go to the estate and go. I mean, we really should be in a situation of everything's been cashed out now and we can start making a little bit of the distributions. But now we're waiting and waiting and waiting. And unfortunately, yeah, we have to engage litigators because this part of law is more of estate litigation versus just regular just probate administration, which can be fairly straightforward. We open the estate, distribute assets, close the estate. This is litigation between our client Tom versus this company, and now we're going to bring in more people. So of course, is this going to take more time? Yes. Is this going to take more money? Yes. We're hoping to resolve it as soon as possible. We're hoping that just by starting more court involvement, that it'll be enough to get the money released. But again, complications that probably could have been avoided, right?
Yeah, definitely. I think it should have been laid out clearly in trust, or, I think what trustees can do is go back to their assets and see if things are retitled, their assets are retitled
Yeah.
correctly. And we always tell our clients, we remind our clients every 3 years, hey, come in, let's see what's updated. And if not, just come in and have a chat with us. And that's when, Meritus and I will ask, did you buy anything new? Is there major changes? And that's when, oh, we have this random bank account, or we have this, and it's
Yeah.
not in a trust name. It's very, very important to see which assets you have. I
Yeah.
would say every year, you just never know.
Never. Mm-hmm.
And this could have been avoided if, the attorney would have been diligent to check the paperwork, check the funding of the trust, and to ensure that
Absolutely.
it's properly retitled.
Yeah, especially that we wouldn't have had this third party issue had we already been involved. So we were not the ones preparing the decedent's estate plan. And had we been involved, we would have checked into this particular asset, see what the beneficiaries are, make sure that it's tied to the trust, all of that kind of stuff. And often people create documents and they set it and forget it, right? They just kind of say, oh, yeah, it's there. And the lawyer never checks in on them. They never think about it. And that's not how you deal with estate plans. I'm always saying it's like a car. We got to have, oil changes. We need to have tune-ups. There could be something major in there that's really going to blow up your estate plan. And this is an example of that. So we always like to have communication with our clients often, as well as every 3 years, come on in and check it out. It doesn't always happen, but we do our best,
Mhm.
right?
Okay.
Is that fair? We also do trustee schools and different ways for educating our clients as well. And I think that's important too. So these are examples of two complicated estate administrations that we're still dealing with. We hope that you've learned something today. Our point is always to do the planning as opposed to the post drama that can ensue, right?
Yeah.
Our preference is to make it clean, easy, and when a person dies, we're just involved to release assets and distribute. There's a bit of paperwork to do in trust administration, but it's much faster. It's
Mhm.
very private, and it's less expensive. So absolutely a much better option.
Yeah, I agree.
Yeah. Yeah. Anything else you want to add?
No, I think you hit home with just ensuring that you have an attorney that is checking in on you no matter what. Even though for us it's every 3 years, we have clients come
Yeah.
every year, every 6 months. A client I'm working on is twice a year. So
Yeah.
we've taught them well and conditioned them to, hey, any changes you have, please come and talk to us. So we're
Yeah.
avoiding the drama, as you said,
That's right.
after.
That's right. Well, thank you so much for joining me on this podcast, and thank you all for listening or watching, and we'll see you next time.
Thank you.